We've talked about how the Constitution was adopted and what its principal elements were. We've talked about the difficulties of getting it ratified by the states. But what was still lacking was a Bill of Rights. That was only one of the objections. There are all kinds of things that people objected to in this new constitutional system. The small states versus the large states was always an issue and continued to be an issue and is not entirely dead as an issue even today. There were objections to the presidency, where it was said a great power was centered and the president was neither assisted nor curbed by any sort of counsel around him. There are objections to the Senate. It was said that its term was far too long, 6 years, and it was far too powerful. A group of people had prerogatives that even the House did not have. There were objections, there were too few members of the House of Representatives. In point of fact, there were only 65 to begin with. And as the years went on, new states were added, new seats were added. And the House of Representatives kept growing in size. And finally, in the 1940s, it had become 435. And a cap was put on it at that point. So there are only 435 seats in the House, and they are divided among the states proportionately. There was a lot of fear about that power of Congress to regulate commerce between the states with foreign nations and with the Indian tribes. That's the basis of the Commerce Clause. And people feared the Congress would do all sorts of nasty things with that clause. There was objection to the assignment to the Supreme Court of jurisdiction on suits between the states. They didn't want the national government settling such disputes. There was a fear that Congress might pass a law abolishing slavery. Now, that was not mentioned among the powers of Congress, but the fear was there. And a lot of people said, well, we've got this thing going and then we may have to amend it, but the amending process is far too difficult. We'll never get it amended. Another group said, the amending process is so easy, we'll be amending the damn Constitution all the time. The basis for all these objections, hesitations, reservations, was fear. They didn't want to exchange a tyranny of George III for a tyranny of a new national government. Moreover, they were creating a republic. Montesquieu, the great French philosopher, had said that republics could be effectively managed only in very small countries. That if you got larger, you were likely to revert either to tyranny or at least to monarchy. And Montesquieu was much respected and very influential. There was a widespread understanding also that this Constitution was trying to do something that was, on the face of it, impossible, namely dividing sovereignty between the national government and the states. Now, sovereignty meant absolute, total control over everything. Now, how can you divide the powers of government between a national government and a set of states and call either one of them sovereign? Because each obviously constitutes a kind of limitation on the other. Some of the objections, some of them are just silly, afraid of things that never could possibly take place. There was one fellow rose in the Convention of South Carolina and said, what is to prevent the Pope from being elected President of the United States? So I leave it with you as to whether that's a feasible possibility. Well, the greatest fear, this new national government would tread upon the established, acknowledged, and cherished rights of the people. And there was nothing in there that prohibited it from doing that. They wanted a Bill of Rights. The convention had deliberately left it out. This was not an accident. It was not neglect. It was not just misadventure. 8 states already have bills of rights in their own constitutions. And it was argued that it was the states that ought to have Bill of Rights, not the national government, because it was in the states that those rights might be threatened. The argument went, if you list a bunch of rights somehow explicitly in a Bill of Rights, those are the rights that are protected. And by implication, those are the only rights that are protected. And it leaves unprotected any rights not listed in your bill. James Madison thought that the way to protect rights was not to list them, but to put their faith in a self-balancing system of limited government. And that's, of course, what the Constitution ultimately provided. Well, there was a motion taken in the convention as to whether to have a Bill of Rights, and the result came out negative, 10-0. When it came time to ratification, several states tried to add a clause or a condition to the effect that it was effective only if a Bill of Rights was added. Well, Congress rejected that entirely. No conditional ratifications. And what happened is they immediately counted that state as having ratified and neglected the question about the Bill of Rights. The politics of it was, however, that in many of the state constitutions, the leaders of the fight for ratification made a kind of unspecified and unrecorded commitment to the opposition that if you'll go ahead and approve it, ratify the Constitution, then when we get it started, we'll propose some amendments to incorporate into it a Bill of Rights. So the system went into effect with the Constitution having no Bill of Rights in it. So when Congress met, a congressman from Virginia named James Madison introduced a series of amendments to the Constitution that would, he suggested, constitute a Bill of Rights. Madison introduced 35 amendments. The House approved 17 of the 35 and sent them to the Senate, and the Senate approved 12 of the 17 and submitted the 12 to the states for ratification, and the states ratified 10 of the 12. I might add that none of them amend the Constitution. What they are is additions to the Constitution. Nothing is there that changes the Constitution in the words of the clauses. It changes the total impact, but these things are additions to the Constitution rather than actual changes. So these 10 amendments were ratified by 11 out of the 14 states. Vermont had now been accepted into the Union. The 3 that did not were Connecticut, Massachusetts, and Georgia. And the funny thing is that in 1939, the 150th anniversary of the Bill of Rights, those 3 states very solemnly adopted resolutions ratifying and approving the Bill of Rights. And there was a little hoopla, and they were just having fun with it. And they did it again in 1991, which was the 200th anniversary. I suppose they'll keep on doing this. Well, the amendments did some fairly obvious things. Let me just review. The First Amendment is the biggest, the most broad-ranging, perhaps the most important. It protects the right of free speech, the right of free press, and it protects against the combination of church and state. The Second Amendment has the right to bear arms. It's the one that the National Rifle Association relies on. The third one provides that soldiers shall not be quartered on the citizens. It happened during the Revolution. It was all fresh in their minds, so they put that in. Number 4 prohibits unreasonable searches and seizures. Number 5, 6, 7, and 8 all have to do with juries, courtrooms, trial procedures, grand juries, petty juries, and so on. The Ninth Amendment provides that the listing of these rights shall not be construed to deny or disparage other rights retained by the people. The 10th Amendment, what it says is that all powers not delegated to the federal government nor prohibited to the states shall be reserved to the states and to the people. Here's really one of the essences of the federal system as embodied in the Constitution. Powers that are not granted to the national government and not prohibited to the states are all reserved to the states. These rights all are specifically addressed to Congress. They are limitations on what Congress can do. Congress shall pass no law doing this. Congress shall not have the power to do that. Now, what's happened is that the courts have played games with that from time to time, and after the Civil War, when the 14th Amendment was adopted, it specifically prohibits the states from doing certain things. And the things mentioned in the 14th Amendment, such as due process of law, equal protection of the laws, those phrases have been construed by the courts to include most of the things that are prohibited against Congress in the Bill of Rights. So in a sense, the courts have taken the Bill of Rights, which was a limitation on Congress, and made it into a corresponding limitation on the states. But basically at this point, we've created the Constitution, and it's stayed with us. It's now by far the oldest existing written Constitution in the world, with the one exception of that of the state of Massachusetts, which was written in 1780, largely by John Adams. So here we are. On September 17, we pay our respects to the Founding Fathers and to the Constitution that they created. And so I bid you farewell and say to you, I've enjoyed this very much. I hope you will read the Constitution and the Bill of Rights, and I hope you will remember these discussions. And now I say to you all, goodbye and good luck.